Your will says everything goes to your spouse, but one form you forgot to update could send your entire retirement account to your ex.
This video is for educational purposes only. Always consult professionals before making legal, tax, and investment decisions. Here's something most people don't realize. A beneficiary designation overrides your will. So it doesn't matter what the will says. If the form says something different, the form wins.
And these forms are everywhere. Life insurance, annuities, 401ks, IRAs, Roth IRAs, health savings accounts, even some bank accounts. Every one of them can have a beneficiary designation, and every one of them can cause a disaster if it's wrong. Today, we're going to show you why these designations matter so much and the mistakes we see all the time. Let's start with the basics. When you die, some of your assets go through your will. That's your probate estate. It's the stuff that gets distributed according to the instructions that you left in your will. But other assets never touch your will. They transfer by what's called operation of law directly to whoever's named on the beneficiary form.
So if your will says everything to my wife, but your 401k beneficiary form says everything to my brother, your brother gets the 401k. Your wife gets nothing from that account.
It never gets to the will. The beneficiary designation controls, period. No ifs, ands, or buts.
And here's the problem. Most people assume the will cover everything. So they spend time and money with an attorney to get that exactly right. And then they never look at the beneficiary forms.
Yeah, those forms are sitting in an HR system somewhere or buried in an insurance company's records, out of sight, out of mind, until it's too late.
Let me tell you what happens when these don't get updated.
Several years ago, we had some clients in their early 70s, and they came in and they looked terrible. And my concern was that there was a bad health issue. And I asked what was wrong. And they said, "Oh, we're getting divorced." I had known them for decades, and I couldn't believe it. It was one of those big surprises. They wanted the split to be amicable. They wanted to, cut everything right down the middle. Well, needless to say, it didn't stay amicable, and that's a whole other story. A few years later, after the divorce, the husband passed away relatively suddenly, and the ex-wife got this letter from the pension board, the husband's pension board.
He never changed the beneficiary. She's still listed. So she now gets several $1,000s a year from his pension for the rest of her life.
And I said to her, maybe deep down, he wanted you to have it. And she said, "No way. There's no way he would have wanted me to have it." But it doesn't matter what he wanted. The form controls. And the rule presumes that had he wanted to change it, he would have changed it, which is why I asked her the question.
We've seen ex-spouses named as beneficiaries more times than you'd think. If you sit in our office long enough, you'll see almost everything.
So let's talk about where these forms actually exist, because they're not always easy to find.
Life insurance, beneficiary designation. Annuities, beneficiary designation. 401ks and 403bs have beneficiary designations as well. So do IRAs and Roth IRAs, as well as health savings accounts.
Yeah, all of them have a beneficiary designation. You can also put beneficiary designations on bank accounts and brokerage accounts. They're often called transfer on death or payable on death designations. They're more common in states where probate's more problematic or even more expensive. So we don't see it much in our state.
The point is they are everywhere, and each one needs to be reviewed and updated, especially when life changes.
The good news is I think most modern 401k and company retirement plans let you see and update the beneficiaries online. They're coming more on statements as well. That's relatively new. But life insurance and annuities, you often have to dig for those records because they're not out in the open.
If you're realizing you haven't looked at your beneficiary designations in years, or you're not even sure what's on file, you're certainly not alone. Consider subscribing. We cover the details that most people overlook until it costs them.
Here's something most people don't think about. Beneficiary designations aren't just about who gets the money. They can also affect how much taxes are paid.
Let me give you an example. Say you want to leave money to your church or your alma mater as part of your estate plan. Where should that gift come from?
If the charity is named as a beneficiary of your traditional IRA or qualified retirement plan, they receive the money tax-free because they don't pay income taxes. Every dollar in the IRA goes directly to them. I think there's a difference.
Yeah, But if you leave them after-tax money from a brokerage account, for example, and leave the IRA to your kids end up having to pay income tax on the IRA distributions.
So let's look at an example of how this works. We have a client whose husband graduated from the Naval Academy, and it's near and dear to both of their hearts. She wanted to leave about $500,000 to the Naval Academy and the rest to friends. She doesn't have any family. So she had about $1 million in IRAs and about $1 million in after-tax accounts. So what we did is we named the Naval Academy as a 50% beneficiary IRA. That's where the $500,000 comes in. The friends get the rest of the after-tax money, or get all of the after-tax money, and then about half the IRA. But at least we're able to get some after-tax dollars.
So the result is the charity gets the full amount with no tax, and the family keeps more because they're receiving less of the taxable IRA. Everyone wins.
What we do for her is we update a spreadsheet every year so she can see exactly who gets what. That's the kind of thinking that maximizes what you're able to do for people and the causes you care most about.
So here's a mistake we see that can be costly: naming your estate as the beneficiary of your IRA.
I think people think, well, my will says everything.
And they definitely think that, yeah.
My will says exactly who gets everything, so I'll just name the estate and the will takes care of it. Probably a bad idea.
When your estate is the beneficiary, the IRA then goes through probate. That means it's subject to probate costs and delays. But even worse, you lose very valuable tax benefits.
The beneficiaries can lose the ability to stretch those distributions over time. That means the money comes out of the IRA or retirement plan faster, and therefore the taxes come due faster.
And the people who inherit may not even be who you wanted if your will is outdated, or there's a dispute, or the probate process goes sideways. You created a mess.
Yeah, the fix is simple. Name the actual people or trusts as your beneficiaries directly on your accounts. Don't route it through your estate.
Now here's where it gets more sophisticated. Sometimes you don't want money going directly to a person. You want it going into a trust.
Yeah, why? Well, the same reasons we talked about before. Could be protection from a divorce, could be protection from creditors, protection from a child who might not handle a lump sum very well.
If your will has a testamentary trust, that's a trust that gets created when you die, but your IRA beneficiary is your child directly. The money bypasses the trust and it goes straight to the child unprotected.
So if you want the IRA protected, you need to name the trust as beneficiary, not the child.
Here's the catch. If you're naming a trust as beneficiary of a retirement account, there has to be specific language in the trust to preserve the tax deferral. Get it wrong, and you accelerate the taxes.
This is where having a personal CFO coordinating your plan with your attorney matters. The beneficiary designation and the trust document have to work together. One without the other, it just creates problems.
One more concept worth knowing. It's called per Stirpes.
Per Stirpes. PER space STIRPES. And it's legal shorthand that means by branch. Here's how it works. So in my case, I'm named as a 25% beneficiary of my mother's IRA per Stirpes. So if I were to die before my mother, and it happens, my share doesn't disappear and go to my other three siblings. My quarter goes to my kids. It's the branch of my family tree.
So like you said, without per Stirpes, if you die first, the 25% gets redistributed to the other beneficiaries, and your kids essentially get disinherited.
And you can add per Stirpes to most beneficiary designations, IRAs, Roth IRAs, even some 401k plans. It's a simple addition. We call it legal shorthand that protects against the unexpected.
The idea is to write these designations if you'll never look at them again, because honestly, most people don't. So build in the contingencies now.
Here's the bigger picture. Beneficiary designations are just one piece of your estate plan, but they have to work with everything else: your will, your trust, your tax strategy.
If the will says one thing and the beneficiary forms say another, you've got a conflict, and the beneficiary form wins every time. Even that's if not what you intended.
We see this all the time. The will is beautifully drafted, the trusts are set up perfectly, but nobody checked the beneficiary designation, and the whole plan falls apart.
That's why, as part of our virtual family office framework, reviewing the beneficiary designations is built into the process. We check them, we update them, and we make sure they're coordinated with everything else.
Because the goal isn't just to have documents, it's to have documents that actually work together.
Beneficiary designations are very easy to overlook. Sometimes they're buried into systems you don't log into. It doesn't feel urgent until something goes wrong.
But they control where a huge portion of your wealth actually goes. And if you get them wrong, the wrong people inherit. Get them right, and you could save your family or loved ones significant taxes and hassle. Now, if you're thinking, what if I want more control over how my money gets distributed? What if I want to protect it from divorce or lawsuits or even bad decisions? The answer might be trusts. In the next video, we break down how trusts actually work, what they do, why you might need one, and how to think about structuring them. You can watch that video now.
So if you're looking at your own accounts thinking, I have no idea what's on those forms, we can help you sort this out. Click the link below and just schedule a conversation.
Because at the end of the day, investing is the easy part. Making sure your beneficiary designations actually match your intentions, that's the hard part.